lecture in medical and legal ethics. This is a distinguished lecture series funded by Alan Siegel, who's one of the graduates of whom we are most proud at Duke Law School, in honor of his brother and leading scholar in ethics and theology, Rabbi Seymour Siegel. Alan Siegel himself earned his law degree from Duke in 1960 and has one of the most successful employment and labor practices in the U.S. He brings that expertise to the law school by teaching a course in collective bargaining and other labor relations courses, and in fact he's also brings his Rolodex with us because he's often having very distinguished people in the labor law field come to Duke. Rabbi Seymour Siegel, whom this lecture series honors, was a man of great integrity whose commitments in life reflect a man of deep personal convictions, participating in civil rights marches with Dr. Martin Luther King Jr. and voter registration drives in the 1960s, protesting the Vietnam War, giving the benediction at the inauguration for President Richard Nixon, and helping to establish the Holocaust Victims Memorial Museum in Washington, D.C., just to give you a few representative examples. For the 41 years before his death in 1988, Rabbi Siegel was associated with the Jewish Theological Seminary in New York City, first as a student and later as the Ralph Simon Professor of Ethics and Theology. He was a distinguished authority in ethics, particularly medical ethics, holding positions at the Kennedy Institute for Bioethics at Georgetown, the Woodrow Wilson Center for Scholars in Washington, and the President's Commission on Ethics in Medicine and Biomedical Research. It's thus particularly appropriate that we honor him with a lecture series in legal and medical ethics. I'm very pleased to welcome as our lecturer today Professor Carl Schneider. He was last here, some of you may remember, 2 years ago when he was the keynote speaker for our 1L career kickoff, where he shared insights into the decision-making of young lawyers. This was research done undoubtedly passing the Human Subjects Review Board, I'm not sure, but with students from some years ago in his first year small section. Professor Schneider is the Chauncey Stillman Professor of Ethics, Morality, and the Practice of Law at the University of Michigan Law School. I actually have a rather elaborate introduction here, but when I arrived this afternoon, I saw that a good deal of it was set forth in your program, so I think I will, due respect to the guest, I think I won't read you material that's repeated there. Rather, just tell you that it's a real personal honor for me to welcome Professor Schneider here. He and I, although Carl no longer teaches family law, he and I share that subject as scholars. He's even though he's tried to get out of the field, he's sought after for his wisdom and balance in a field that is often a lightning rod for emotions and political debate or screaming, however you want to put it. But he's a particularly rational voice in this turbulent sea, and really very pleased to welcome him here to speak today about ethics. So, Professor Schneider.
Well, I'm, of course, very pleased to be here for many reasons. One of them is that if family law had been populated by more people like Dean Bartlett, I would still be doing family law and not be able to talk with you about ethics, which would be a pity in some kinds of ways, because I think that the topic of the lecture series is an enormously important one that law schools and even medical schools don't do a very good job with. They are not as animated by a desire to have their graduates go out and practice medicine or law ethically as I think they should be, and as I think some other professions do manage to be. So when Dean Bartlett asked me to come and do this, I was excited by the idea of helping the professions to think about what it means to be an ethical practitioner of medicine and an ethical practitioner of law. It may just be that my problem is that I am the grandson of ministers on both sides, and there I can't give up the idea of a little homily. But as I began to think about what would actually be interesting to you, it occurred to me that homilies might not be the first thing on your list. And there is something kind of silly about a lecture, I confess. What's silly about it is that it would be so much more efficient if I just went home and wrote down what I wanted to say, as indeed I've already done, and if you could read it at your leisure and at your comfort. So with that constraint, I tried to think about what I might talk about that might actually be useful in a way that lectures aren't always. And so what I've decided to do this afternoon is to try to talk with you a little bit about some ideas I am currently having that are not fully developed, but that seem to me to be especially important. Ideas, at least in terms of the way that bioethics is now being thought about. Now, for those of you who are not in medicine and are not in bioethics, I think it's hard to grasp just how much that field, those fields, have been dominated by a single principle and a single doctrine. The single principle is the principle of patient autonomy, that patients ought to be self-governing in their medical situation, that they ought to be able to make their own medical decisions. The subsidiary doctrine that flows from the principle of autonomy is the doctrine of informed consent, the doctrine that patients must be given enough information that they are capable of making their own medical decisions. This doctrine has metastasized out of the core area of doctor-patient decisions into one after another decision that is related to medicine. Let me give you a few of the examples. Our entire system for protecting human subjects in research is focused around the idea that what you have to do is to give potential research subjects the information they need so that they can decide whether or not they want to participate in research. The latest fad, if I may put it in that pejorative way, in managing managed care is consumer-directed health care, which is the idea that if we just let patients act as consumers and make wise purchasing decisions about what medical care programs they want, what managed care programs they want, what insurance policies they want, and indeed what specific medical care they personally want to buy, that costs would be controlled better and that patients would get more of what they actually want of their medical care than they do now. Our whole system for regulating federally the confidentiality of doctor-patient relations centrally turns on a version of informed consent. I don't know how so many young people in the audience, they never go to hospitals. For those of us who are over 50, we know that, I think, am I on here? Yes. Let me just tell you what happens in real life. You go to the hospital and they give you a form in which the hospital does its duty and reveals to you its privacy policies. In the case of my institution, that document is 9 pages of very small, single-spaced type. The idea being that I now know what my privacy rights are, and therefore I'll be better able to use them. Much the same device has been used by the federal government again when it comes to advanced directives. People weren't using advanced directives, and so Congress passed the Patient Self-Determination Act, which requires that a hospital or a physician, when it encounters you, encourage you, essentially, to use advanced directives. A rather sinister thing when you go in for what you think is a minor procedure, and they say, now, in the event that you should become so incompetent that you can't make your own decisions and are on the verge of death, what would you like us to do? Informed consent works in another way as well, and that is sometimes reformers want to accomplish a substantive goal, and they use this procedural device of informed consent to accomplish it. For example, a number of years ago, several legislatures, about 20, decided that women were having too many mastectomies. And they passed a statute saying doctors must give women facing breast cancer treatment the following set of choices. with the idea that once the patients were properly informed, they would be choosing lumpectomies and not mastectomies. In fact, what happens in real life is that this is the situation before the statute in terms of the number of lumpectomies. After the statute, the rate of lumpectomies goes up for about 6 months, and then it returns to the status quo ante. But the plan was to use informed consent to accomplish a substantive goal of changing the way that doctors and patients interacted. Now, this idea, this doctrine, dominates the ethics of medicine. What does it do with lawyers and clients? And the short, very crude answer is almost nothing. There is virtually no analogy in law to this doctrine that dominates the ethics and the legal regulation of doctors and patients. And in fact, I stumbled across the other day a wonderful passage from the Hazard casebook, certainly one of the leading casebooks in the field, that says flatly, the idea that lawyers and clients should share legal decisions is difficult to reconcile with several considerations. For example, the lawyer knows more about the legal aspects of the problem than the client, and more than the client practically can be told. Now, if a doctor had said this about medical ethics, a shiver of horror would have run up and down the whole profession. It's like somebody jumping up today and defending the abolition of the 19th Amendment. It's just inconceivable. So why is it that lawyers are happy to impose on that profession this onerous duty of informed consent, but don't feel the same enthusiasm about imposing it on themselves? Is it because it's always easier to impose burdens on other people than on yourself, or are there some reasons for this difference? Well, before I try to answer that question, let me ask another question. How does informed consent actually work in the profession which has made informed consent its apotheosis in medicine? Well, I spend more and more of my life reading facts. The older I get, to be entirely honest, recklessly honest, the less I care about theory and the more I care about how the world actually works. And one of the truly lovable things about doctors is they really care how the world actually works. And so, if I may say so, unlike law professors, they go out and they do little experiments to find out how the world works. And what has an Everest of studies revealed about the success of informed consent? The answer is now, I think, extremely clear, and I have decided that it's the last time, for me at least, to face that Everest. The answer is informed consent has consistently failed in achieving the purpose for which it was introduced, and it is doomed always to fail no matter what we do. Informed consent does not and cannot put patients in the situation in which they can make intelligent medical decisions for themselves. Now, what I'd really love to do is just spend the rest of the time reading you from the studies because they're so deliciously deadly, so damning in their unanimity and in their force. But let me just give you a few samples. First of all, a very recent and very thorough study tried to listen to tapes of actual encounters between doctors and patients to see the extent to which doctors were actually giving patients complete information so that they could make intelligent decisions. And this study, the Braddock study, quite a well-known study, found that in 9% of the encounters, patients were given complete information, enough information to make their decision. That's one study that says doctors aren't giving patients a lot of information. The second study is one by a colleague of mine named Angela Fagerlund, and she studied very large pools of women facing decisions about breast cancer treatments. And what she found was that only about half of the women that they interviewed understood what the mortality rates of the two primary treatments were, and only 1/5 understood what the recurrence rates were. Now you may say, oh well, these women were obviously making a decision on some other basis. But they weren't, because Angie also asked them, what is the most important consideration to you? And it was mortality and recurrence rates that were what really mattered. Furthermore, these were women who felt that they'd been well informed and who even had gone to some trouble to educate themselves about these choices. So you say, well, okay, what's going on now doesn't work, but we can make it work if we really educate patients properly. So that brings me to my third study, which is a study by a man named Hertz, who had patients who were receiving some standard kinds of neurological procedures, including the famous one from Canterbury versus Spence, for those of you who enjoy those sorts of things. And what he did was he sat down personally, individually with a patient, and tried to give the patient all the information he thought the patient needed, and used audio-visual aids and all of the other things that we think people ought to use to help patients understand things. Then he had a trained nurse educator do the same thing with the patients. And then he brought the patients and their families back for a third encounter with him, where he did all these things all over again. And as you will already have anticipated, the result was that patients overwhelmingly failed to understand the basic kinds of risks that the procedures involved. Given multiple choice questions, the patients got about half of them right. When they were asked the questions open-ended, they got about a third of them right. Okay? Now, this brings me to tell you about a puzzlement that I have had for a long time now about informed consent. The people who really are enthusiastic about informed consent are people like me and the teachers in this audience. They're people who spend their lives teaching. Okay? If anybody ought to know how hard education is, it ought to be us. I don't know what kind of experience you all have when you open up your blue books. My experience is heartrending. Simply regurgitating the facts that I told them over and over again. I said, this could be on the exam, I say in class. And I open up the blue books, and there is this garbled. I won't discourage the students by telling them just exactly what I find, but it really leads you to think that teaching and learning are humblingly difficult things. And so the idea that you're just going to have a doctor and a patient get together and have a little chit-chat and have successful education take place seems laughable on its face. But what I want to do for a few minutes now is to suggest to you some particular reasons that we ought to be particularly nervous about the idea that informed consent is really going to bring patients to a point where they can make intelligent decisions about consumer-directed health care or their medical treatments or about participating in research topics or what have you. Well, one of the first things you surely need if education is to succeed is willing teachers and willing learners. And in the medical context, you don't really have that. Or at least you have begrudgingly willing teachers and learners. Doctors have, in an important sense, accepted the idea that their ethics call on them and that the law calls on them to provide patients with education and to give the patients a chance to make a choice. But doctors are, at heart, deeply skeptical about this enterprise. And they're deeply skeptical for a lot of reasons. One of them is that they're skeptical of anything that comes from the law. But another one is that they know that they can very strongly influence the choices patients make by the way that they frame the alternatives. They know that. They all know that. And they gleefully give you examples of how they can present a choice fair-mindedly one way and fair-mindedly another way and produce radically different results. They also know just how discouragingly hard it is to try to bring patients up to speed on these kinds of decisions. Now, patients are interesting because in one way, they say that they really want a lot of information. They actually don't want as much information as they think. They say, for example, that they want to know every side effect, no matter how unlikely and however trivial, of a treatment. And they say that because they just don't realize how many hundreds of virtual irrelevancies that would mean presenting to them. But there's a very significant fact about patients' desires. They do want a lot of information, but at the same time, they very often do not want to make their own medical decisions. They want the information because they want to know where they are. They want to know what their situation is. They want to know what is going to happen to them. And if you really press them on this, why do you want this information? This is for bright patients. They say, well, I just wanted to know. But it's not information that they want to use for making a decision. So that they don't respond as students in the way that they would need to if they're going to assimilate this information and use it for making a medical decision. So at the very beginning, we start off with a major barrier to success, and that is that you have skeptical teachers and reluctant students. The next problem in teaching is a very obvious one. It's a lot easier to teach easy things than hard things, and medical decisions can involve some very, very difficult kinds of learning, as well as very difficult kinds of choices. In fact, I often think that there is a kind of inherent limit to informed consent because of this dynamic. You have often some quite difficult kinds of learning to achieve. There are a lot of things that you need to understand in order to make the decision well. But at a certain point, the very volume of information you need to assimilate overwhelms you. And you don't even want to look at the document that you're given, much less to try to engage with it richly. So there is a tension between thoroughness of the education, completeness of the informed consent, and the actual success of patients in assimilating it. This has gotten to be a very large problem with IRBs and informed consent in patients who are considering becoming subjects of research. IRBs increasingly insist on extremely demanding disclosures, very, very extensive disclosures of every conceivable risk. And the result of that is that you have 25-page disclosure documents. We cheerfully assign our students 25 pages of reading to do, but they have to do it, sort of. Patients don't, and the result is they simply don't even take the task on. So the difficulty, inherent difficulty, is always there and makes this educational process very difficult. The next thing that makes the educational process very difficult has to do with what I think is one of the hardest things about teaching, which is that once you become an expert in something, it is very difficult to put yourself back at the stage of being a novice. I know that covenants that run with the land is a really simple thing. Okay? I can't imagine why it confuses people. But 25 years of teaching property has convinced me that it is, in fact, a hard thing for people to learn. And to be honest, I can remember sweating blood when I was a first-year law student trying to figure out equitable servitudes and covenants that run with the land. So I can't put myself back in the situation of being a novice, and so it's hard for me to know how to coach the teaching, how to coach the student, how to set the agenda for the student in a helpful way. But the problem actually goes much deeper than this. The problem is not just that an expert speaks in a professional vocabulary because that's a convenient way of communicating complex ideas. The problem is that patients do not know the words for lots of things that doctors think are quite commonplace. A word like chronic does not mean anything, nor the right thing, to lots of patients. But it's worse than that. About 20% of the population thinks that never means something other than 0 of 100. And about a third of the population thinks that always means something different from 100% of the time. These are common words in common usage. I myself had always thought until a couple of years ago that always meant always and never meant never, but to a large part of the population, it doesn't. Now, the next problem in teaching is one that you never see discussed in the literature and that I have deliberately avoided discussing, and that it is very difficult to discuss. And it's difficult to discuss because even to state the problem makes you seem arrogant and contemptuous of patients. And I hope I'm not arrogant, and I know that I'm not contemptuous of patients. I have been very blessed in my life at being able to spend a good deal of my professional time in interviewing patients and talking with them about their lives. I've spent a large part of my time interviewing dialysis patients, people whose kidneys have failed and who often have many very serious illnesses. And they handle their illnesses and their lives with a courage and sense that I can only admire. So when I tell you what I'm about to tell you, it is not because I think that these are foolish and stupid people who oughtn't to be allowed to make their own decisions. It's because it's a real fact of learning that gets in the way, and that is that a large part of the American population is barely literate, is barely numerate, and 50% of the population is below average in intelligence. And the intelligence part is important because it's not just a question of using your intelligence to solve a problem, it's that your intelligence influences your ability actually to learn facts, to be able to make enough sense of them that you can understand what you are being told. The literacy problem is much graver than you think. If you live your life in a place like Ann Arbor or Durham, you will think that the world is wonderfully literate. In fact, a quarter of the population is functionally illiterate, and more than another quarter of the population is just marginally past that point. These are people who cannot read the little appointment slip that they are given when they go to the hospital. They can't read what is written on the label of their prescription. There are also people whose skills with numbers are very limited. And believe me here, they have my sympathy, mine are too. But the standard test you use for measuring the numeracy of patients is a simple 3-question test asking people to do things like to say, what is 1% of 1,000? Okay? A question you ought to be able to answer already in your minds. But a third of the population asked these 3 questions can't get any of them right. Okay? Success at understanding communications, for example, about what mammography does to reduce your chances of dying of cancer, those success rates range between 7% and 33%, okay? Largely because of these kinds of difficulties. So when you come right down to it, you have an extremely serious problem in teaching. A problem that I haven't even begun fully to describe. For example, the problem of inadequate time is very important. Let me give you one quick story about a gentleman whom I met when I was rounding with some physicians at a hospital. He had an aortic aneurysm, abdominal aortic aneurysm, which could kill you at any moment by bursting. And he had emboli in his legs that seemed to be spreading to his lungs. To put it crudely, the treatment for the aneurysm is to try to make the blood clot more effectively. The treatment for the emboli is to try to make the blood clot less effectively, because emboli are blood clots. The physicians were trying to figure out exactly where he was, how long those emboli had been around, and so on. They presented all of their data to him. He was an elderly, wonderfully sweet man who even said nice things about the hospital's food. And They gave him this bolus of information, this huge slug of information, and then very properly said, "Do you have any questions?" He said, "No, whatever you fellows want is fine with me." Then they said, "So what do you think your problem is?" And he said, "I have thick blood." Now at that point, we were behind time in rounding, several other patients to see, even though the time had expired. And here was this patient whose treatment choices were at that very minute life and death choices. He could die of either one anytime. The attending said, "Thank you very much, we'll see you again tomorrow," and left. What should he have done? Now, what I've tried to do is to suggest to you some of the very serious reasons why I think that informed consent doesn't work and can't work. Very quickly, I want to suggest to you that we could approach this from another angle and talk about some analogies. For example, mandatory disclosure is very common. It's what happens in securities markets, what happens with Miranda, it's what happens with truth in lending laws. It never seems to work the way that it's supposed to, and with consumers, it basically doesn't work at all, partly because the information never really even penetrates into the consumer's mind. The only exception seems to be that consumers are genuinely interested in and pay attention to several of the data that are now mandatorily revealed in food labels. And I think you can see what a wonderful effect that has had on obesity rates in the United States. That's the one that works. Look at it from another way. When we really want to get something done, we forget about informed consent. The same people who are enthusiasts about informed consent are also enthusiasts about advance directives, living wills. And what they do is they go around urging people to sign living wills. Living wills are statements that essentially say, "Kill me if you think it's a good idea." This is a serious decision. Are people who sign living wills required to understand what they are doing? Is there any informed consent for that? No. There is for a flu shot. But we really want people to sign living wills, and so we carefully do not require that they understand what they are doing when they sign these documents. And folks, I'm here to tell you, they don't understand. If you ask somebody with a living will, "Do you have one?" the first answer will be, "I think so." Okay. The second question you ask is, what does it say? Pause. It says, "I don't want to be a vegetable." That is the verbatim line that you get over and over again. And indeed, who does? Unfortunately, that's not what the document actually says. I won't even begin to tell you what informed consent looks like when it comes to doing something like waiving your constitutional rights, which you can do without even having realized that there was a constitutional right to be waived. I won't tell you anything about the most solemn communication of information in American law, which is the judge's instructions to the jury. Okay? My colleague Phoebe Ellsworth has studied the success of those communications. And the upshot is that when tested, jury members tell you what the law of the case was exactly as accurately as if they were flipping a coin. And that's not because they don't care. They work hard at it. They discuss it in the jury room. They argue about it. Unfortunately, the arguments do not produce a more accurate understanding of what the law is. And if you look at the extent to which consumers go out and try to acquire information about important decisions they are making, sua sponte, like retirement planning, you discover that people do, in very large numbers, do not take the most basic steps and do not know the most basic things. Something like a third of the country of people polled have not even tried to plan for their retirement. Although they are quite confident that everything is going to be all right. So if you look at the analogy, you once again see a failure of this device of mandatory disclosure. Now, in my zeal to give you all of these data, I've used up a lot of the time I was going to spend in trying to talk a little bit about what we do if we acknowledge that informed consent has failed of its purpose. And I suspect there'll be some questions, if we have time for questions, and I will be happy to try to say then what I would otherwise have said now. But let me suggest a couple of things that I've been thinking about. First, I've noticed that law professors have a very strange reaction to criticism of a doctrine. If you prove flatly and absolutely that the doctrine doesn't work, does not achieve its intended purpose, law professors scurry around, desperately trying to find something else the doctrine does. If it doesn't do what we intended, there must be something that it still does that would justify us in keeping that. I don't exclude myself from this. I teach my students how to do that. But if you think about it, it's a kind of an odd procedure to assume that what our job is to justify the current regime, even in the face of spectacular failure. So let me give you a couple of examples of these maneuvers that I have encountered when I talk with my friends about this very disturbing information about the success of informed consent. And the first thing they say is, well, half a loaf is better than none, isn't it? Isn't it better that patients should have information than not have information? And I think the answer is that half a loaf isn't better than none. What we're talking about here is bringing people to a state where they can make a good decision. Not just about what medical treatment they're to have, but about what insurance policy they're going to buy, about how they're going to deal with the confidentiality rules of their hospital, whether they're going to participate in research, a decision they have to make virtually by themselves. All of those are important decisions. And you can be led very badly astray by misunderstanding one fact. And what I've shown you is that patients massively misunderstand facts, numerous facts that are crucial to their own view of how they ought to make the decision. So I don't think it's true that half a loaf is better than none. Another maneuver that I see is that people say, and this is a very common law professor move, yes, it's true the doctrine doesn't accomplish its purposes, but it serves important symbolic purposes. After all, informed consent is a symbol of our respect for human dignity. I'm always nervous about this move because it's so hard to know how a symbol really works. In this case, I don't believe that anybody thinks that informed consent is a symbol of our respect for human dignity, except people who teach in law schools and medical schools and possibly schools of philosophy. Because if you ask a doctor what informed consent is all about, he doesn't say, it is a sign of my respect for human dignity. He says it's another one of those damned requirements those malicious lawyers have imposed on me, even though it doesn't work and it's just a waste of time. And the patient does not think that because she is asked to sign one more form, that her human dignity is better off. On the contrary, if anything, it seems to me that informed consent is so easily satisfied by having the doctor hand the patient a form that it reduces the essential respect for human dignity that we ought to be interested in. Now let me come at this problem from one more angle. We're interested in the autonomy of the patient. One of the fascinating things is that when we think about the patient's autonomy, we've never really bothered to go ask patients what they think would be in their own interests. And so I started to do that with patients. I said, what are you after from your... And they said two things. First, I want a doctor who is competent, and I want a doctor who cares about me. I want a doctor, this is a very common phrase, who cares whether I live or die. Far too often, patients feel that they get neither. That they have to hunt for competence, and that the kindness element is almost unfindable. Let me give you a couple of ways in which I think that is true, by telling you a couple of stories. One of them is a story that is told by Reynolds Price. Is he still at Duke? He wrote a truly wonderful book about the experience of being ill, and you should all read it. He tells the story of lying on a gurney in the hallway of the Duke Medical Center, being approached by his surgeon, who told him, quote, with all the coldness of a steel cheese grater, that he had the biggest tumor the surgeon had ever seen and that he was going to die. When I started to write a book I wrote some years ago on autonomy, I thought I was writing a book about how patients made decisions. So I read hundreds of memoirs like the one that Reynolds Price wrote about the experience of being seriously ill. And I tried to get a pile of index cards in those days that told stories about how patients made decisions. And I wound up with a pile yay big. I had a pile this big of stories that patients told about the experience of being treated in a harsh way or in a kind way by their physicians. What truly animated them were those kinds of things. And the Reynolds Price story vividly captures the failure to get that basic kind of human decency and solicitude from physicians, matched, I emphasize, by a stack at least as big of stories of enormous gratitude from people who had been treated in even small kind ways that mattered a lot to them. But let me give you another example of this problem of competence and kindness that is so much at the fore of the way that real patients think about their lives in a way that has so little to do with informed consent and so much to do with real human dignity. The fact is that a very substantial amount of the pain that is suffered in American hospitals is unnecessary. It's treatable pain. The number of people who die in unnecessary, that is to say, treatable pain, is very large even in good hospitals. We know that, and we have not done anything about it. I always remember the time when I was visiting a hospital, and a patient was transferred in from another hospital, actively dying of cancer, lying on the gurney, his sheets all askew because he had ripped them off him. He had torn out his IV. There was blood every place. And he was shouting over and over again at the top of his lungs, "Don't let your children die in pain like this." When we think about how to use our reformist energies, the energies of law and the energies of ethics, when we think about what might most promote human autonomy and human dignity, I think that it's time for us to abandon more and more attempts to tweak informed consent and to begin to think much more basically about what we need to do to make the relations between doctors and patients work better, and to make the way that patients are treated by managed care organizations and by hospitals more successful and more decent. Let me close with one more observation here. There really is a direct conflict between informed consent and better care. And the reason for that goes back to what I said earlier about the difficulty of education. So the problem is that patients need more than one kind of education. More urgently, often, than they need information to make a decision. They need information about how to care for themselves successfully. And if education is as difficult as I've been supposing, we're going to have to pick our battles. One last datum. 30% of the diabetics in the United States have their cholesterol and their blood sugar under control. 70% do not have those two basic things that will prolong their lives and prolong their autonomy, because nothing promotes your autonomy like being healthy, and nothing degrades it like being sick. Doctors have a very difficult educational burden here in bringing these patients to a point at which they are caring for themselves. But we know from studies that in many cases, doctors don't even have the time to ask patients whether they have a question, much less to do complicated things like trying to educate them about these issues. So I should come back to the place where I began and to the title, which after all committed me to talk about two professions, and say, so should lawyers congratulate themselves on their success at having escaped this foolish doctrine? And I think there you have to take one more step and remind yourself, I certainly remind myself, of why we wound up with this metastasizing concept of informed consent. The reason was that doctors were not treating patients as well as they should be treated often enough. Lots of doctors are fabulously successful and quite wonderful, but many of them are not. And the same thing, of course, is true of lawyers. Now, one reason that law has not been forced into informed consent is because a lot of lawyers are regulated by the market. If you're General Motors and you're a client, you're not going to have to worry very much about informed consent. You can find out from your lawyers what you want. And lawyers complain about their clients, like General Motors, because they have so much power over the lawyers. Nevertheless, there are lots of lawyers who deal with individual clients. So I think where we come back is to the real topic of this lecture series, which is how do we arrange the world so that vulnerable patients and vulnerable clients are looked after properly, are given competent and solicitous care. And there the law has very few weapons, and professions have done their best to continue to regulate themselves. But that's a topic for another lecture. So let me stop, and I think Kate has obliged me to take questions.
I want to thank you very much for that lecture. And there will be time for a couple of questions. Before that, I just want to say we have had other members, past or present, of the President's Commission on Bioethics. We've had other Supreme Court clerks, as Professor Schneider has been. We've had other people who have a long list of distinguished awards, including interdisciplinary awards that involve collaboration between law and the sciences and law and medicine. But I'm not sure we've had at this podium for this lecture before anyone who's so well combined the experience and grounding in both medicine and law. And I really appreciate that you were able to come and provide this talk for us today. I also want to, before I turn to questions, recognize Rochelle Siegel, who's representing the Siegel family here today at this lecture. Rochelle, if you will please stand, I appreciate that. And I won't introduce the faculty who are here, but I'd also like to recognize Sina Shim, who is a psychiatrist and the widow of Professor Mel Shim, who really represented at Duke Law School for a very long period the connections between law and ethics, medicine, theology, and I'm so pleased that she's here today to enjoy this with us. So there's room for, time for a few questions, maybe for 5 minutes, so what say you? Yeah, right here.
Thank you. As far as I understand, your argument implies that elitocratic decisions are better than the other kind of them, and I say that because, well, your data seem to indicate that patients do not educate themselves, right? And it's true that you can drug a horticulture, but you cannot make it think. On the other hand, at least in the political decision-making, we subscribe to the idea that self-governance is better than elitocracy, even when you have uneducated voters. And, you know, an optimist may say that we do that because it creates incentives for people to educate themselves. A cynic may say that, well, it's a good way to make people feel happy and to manipulate them. And I was wondering, I was wondering what your thoughts about that would be, and what kind of route you would take if you were given an opportunity to reform.
Yeah, so you dreamer.
The system.
No, I think those are exactly some of the right questions. And let me try to say very quickly a couple of things. First of all, you might be asking yourself, how in the world does Schneider think people stumble through the day when he describes this miserable mass of problems they have in learning complicated and foreign things? And I think the answer to that is that they are complicated and foreign things in which people are not much interested and do not wish to have to be interested. People do a spectacular job of running their own lives a very large part of the time when they are doing the things that are interesting and important to them. But they're picking their battles. They're thinking about the things that are what matter to them. Learning about medicine is not something that most people want to have to do and want to do. So the answer is we're very good at thinking about problems that we're familiar with and that we're interested in, and not very good at having to learn whole new ways of thinking about complex and foreign kinds of things, which is to say that what a lot of us want out of our lives is for somebody else to take away from us the nauseating burden of learning what cell phone I ought to buy, what plasma TV I ought to buy, what company I ought to use for this, what doctor I ought to use for that, and so on, so that we can think about the things in our lives that are important. Now, that leads me to the next part of your question, which is about what rule I would use instead of informed consent. Well, first of all, I do want to observe that lawyers manage to do just fine, in their own views at least, without any such rule, so maybe we don't have to find a substitute. But the second thing I would say is, I think any blanket rule is a bad mistake. Medical decisions itself is a hugely capacious category. It includes things like, do I want to be alive or dead? A decision that I think doctors have little to contribute to. It includes things like, will antibiotics make my cold go away faster? Where I really shouldn't be allowed to be making my own decisions because it has bad consequences for the rest of us when I make the wrong one. It's a very capacious category. Plus, doctors are very different and patients are very different. Patients differ depending on what kind of medical decision they feel. If you are feeling pretty healthy, your view about medical decisions will be quite different if you're old and sick and decrepit. Okay? And I know more about this than most of you here, so you'll have to take my word on that one. The older and more decrepit you get, the less zealous you become for seizing control over your own medical decisions. So if I had to give doctors some ethical guidance, what I would tell them, and what I do tell them, is your job is neither to make decisions for the patient or to give patients the information for making decisions. Your job is to help them make decisions in the way that is best under those circumstances. You will say, that's not very much guidance. And I will agree, and I will say, but it's for the same reasons that we fall back on the reasonable person standard in torts. It's because you cannot break down human complexity into simple rules. With a short answer would make it easier.
As long as you want.
You can just say yes or no to this one, actually. Just wondering
Surely
I'm wondering if informed consent insulates doctors from medical liability.
No, they think it does and it doesn't.
Okay.
On the other hand, how many doctors are there in the room? Okay, well, don't tell anybody, because I'm about to reveal a deep truth about the law of informed consent, which is it's essentially a paper tiger. It's almost impossible for a doctor to lose an informed consent action standing by itself. They're never brought by themselves. They're usually brought as part of a malpractice action. And essentially, the question is, would the patient have made a different decision had the doctor fully informed the patient? And if the doctor is informing the patient competently, the answer to that question is, well, the average patient would do what a competent doctor would suggest, and therefore, more information would not have changed the patient's behavior. Even when patients win informed consent actions, they win very little money. So as a doctrine about making medical decisions, informed consent looks a lot fiercer than it is. On the other hand, we base, as I said, our entire system of regulating human subject research around the idea of informed consent. And the whole move toward consumer-directed healthcare crucially depends on people being able to use information of this difficult kind. So in those areas, I think it matters a lot what attitude we take toward informed consent. But doctors are wrong when they think that they're insulated because they got the patient to sign a form. Yes, sir.
I want to go actually to human research, because it seems to me that your position, and correct me, is that, if I'm wrong, is that informed consent really doesn't work. But it seems to me that it's done a great deal to prevent some of the worst abuses of the past century committed by the medical profession on human subjects. That is, I assume people, if you said, hey, would you like to have your syphilis go untreated so that we can observe its effects on humans, they would say, well, I'd really rather not. Or similar studies where there was absolutely no information given to the test subjects, and they were subjected to experiments that really they wouldn't have consented to if informed.
I am looking for evidence that in today's culture, which is hugely different from the culture of Tuskegee or Nuremberg, that in today's culture, the requirement that patients be given information before joining a research study has prevented serious harms from happening. And I am not, it's very difficult to prove, but I'm not aware of it. And I think, if anything, it's possible that what our system does is to impose large costs on researchers and on patients in terms of an elaborate procedure that manages to let some pretty serious things go by and that prevents some good research from being done. Let's take it one step further. Remember what I said about the success of informed consent. One of the classic examples of the failure of education in research is the attempt that we've been making for decades to convince patients that just because we're doing an experiment doesn't mean we think that they're going to be better off for having gone through the experiment. That it's not our intention to be curative. A lot of the important testing is about the dangers of the drug and not about the benefits of the drug. And no matter what you do to try to convince patients that that's true, a very substantial number of them do not assimilate this information. So it strikes me that a more sensible approach may be something like having the IRB say, some research is just terribly dangerous, and we're not going to prevent it or we'll allow it to happen under unusual circumstances. And then to free up the rest of the research from the burden of asking patients to read literally 25 pages of disclosures that you know for a fact that they will not read and will not understand.
Let's give one more round of applause. There were many hands, people with questions and not time to ask them. So please join Professor Schneider at the reception out of the loggia, and you may ask him your questions then. Thank you.
Terrific. Thanks, Kate. Well, I thought about whether I should be Solomon.